Trial date has been scheduled. Donald Trump apparently will be seated May of 2024 for a full-blown jury trial on the classified documents case in Florida. Of course, May is before November, and that means this trial evidently is going to be happening before the election. Now, some people on the left were very happy about this. They were saying, perfect. We wanted to get Trump in trial and convicted so that we can call him a felon before people go into the voting booths in November. And they think that that May trial date is going to anchor that in there hard and fast, but I'm not so sure about it. I think that that might just be a nice little stepping stone to a continuance that postpones this back into November, because May plus 6 months equals November, and that feels like about what a continuance would be to postpone this until after the election. Now, while the left was very excited about it, Donald Trump also declared victory on this, and I think because he gets it. This is what they posted via his spokesperson. They said, today's order by Judge Cannon is a major setback to the DOJ's crusade to deny President Trump a fair legal process. The extensive schedule that we're going to go through here allows President Trump and his team to continue fighting this empty hoax. Crooked Joe Biden is losing and attempting to use his weaponized DOJ against his top political rival, a disgraceful and un-American abuse of power. Crooked Joe will fail, and President Trump will win back the White House for the American people. July 21st, 2023 via Trump spokesman. You see, I think there's a lot of truth to this. There is a lot of time on the clock left. The judge did set a date, and when we were going through the request, remember the government wanted a December date. Trump wanted an indefinite date. Trump said, well, we don't really need to anchor it in there, Judge. I don't really know what our schedule is going to be like. Let's just leave it undefined, which is a rare thing. I mean, that's almost never done in criminal law because we've got speedy trial rules and regulations, and we can't lose sight of that end date. We are always calculating the time that elapsed between the charges, the arraignment, and then the ultimate conclusion of the case, and we've got calculations there. So we were wondering, where are they going to set this thing? Judge dropped it right in May. Now, in between now and May, there's going to be a lot of speed bumps. There's a lot of bumps in the road as we go through this. But before we get to the final ruling, let's see how the hearing went. What happened on the day when this was all debated? And here is what we learned, courtesy of our very good friend, Julie Kelly, on Twitter at Julie_Kelly2. She writes the following. She says, Judge Aileen Cannon set a May 2024 trial date. These are the excerpts from the hearing. And Cannon starts the hearing by criticizing the DOJ and their weak attempt to confer with the defense. And previously here, remember that the DOJ moved for a protective order, and they said, Your Honor, we've been trying to call Donald Trump and his team. We've been like, hey, you know, it's Friday, it's Saturday, it's Sunday. Can you meet with us? And they're like, no, we're busy. It's, you know, it's Saturday, it's Sunday. And then I think they sent an email on Friday night, and then they were angry filing motions on Monday morning. They're like, Your Honor, they didn't get back to us. And the defense is like, hey, whack jobs, we're not on your beck and call. Sorry. And we're going to see where the judge picks up on this. Here's what they say. The court, Judge Aileen Cannon. All right, everybody, talking to the prosecutor. So I've heard about, I think you said government prosecutors about what, 1.1 million pages? Is that what you said? Jay Bratt, the prosecutor, says, that's correct, Your Honor. Okay, and so 1.1 million pages. And in terms of the footage, how many months does that run through, all the surveillance? Bratt says, so, well, it covers a 9-month period, but not all the cameras were, but it is not all the cameras at Mar-a-Lago or Bedminster. Not all the cameras were always running. And the retention period that the Trump organization had, it varied from camera to camera. And so it is not a solid 9 months of video. So in some cameras, Trump would, retain it for, let's say, 30 days. In other cameras, he'd retain it for 6 months. Others would be 90 days. So we don't know exactly how much is in each batch. Court says, okay, well, I haven't seen what the objections are to that. Was there meaningful conferral on Section 3 of this rule? I wasn't sure why it was filed without meaningful conferral pursuant to the rules. So the judge is saying, did you meet with Trump's people here? Rule Section 3 says you got to do all this conferral. Did you do that? Prosecutor says, so we tried. We reached out to them. Judge says, when did you try? When was that? He said, so we had an email exchange on Friday. And Friday, we were trying to set up a call on Friday, and we were advised by counsel that they were tied up. And we saw that in their filing. Your Honor, they didn't get back to us. Bratt says, so Judge, I suggested that we could make some time over the weekend to talk if that was possible. And we didn't hear a response from them on that. The judge says, okay, so hold on. She says, so you tried to confer on a Friday before filing on a Monday, something that is presumably quite important. That seems a bit rushed. That's interesting. You're filing a substantial protective order that's going to be limiting the defense and tying Trump's hands, and you just drop it on them on a Friday night, and then you file on a Monday like, hey, Your Honor, they're not cooperating. cooperating with us on this. That seems a bit rushed. That's not meaningful conferral, prosecutor weirdos. This continues. Julie tells us that the DOJ has 1,500 pages of classified material, including various files from NARA. The May subpoena production, the Mar-a-Lago raid, both included. Trump's lawyers can see about 80% of it, but the Department of Justice, under interim security clearances, is what they said. Now, full clearance is going to take 2 months. Julie tells us, here's how the DOJ wants the judge to treat Trump. Looks like this is a government prosecutor speaking. Says, Your Honor, the second thing I'd like to address briefly is something that is plainly in tension here, and that is the defense's view that Mr. Trump in particular should be treated differently in light of the circumstances, whether it's the fact that he's a former president or the fact that he's running for president or what have you. Government prosecutor, probably Jay Bratt, says, in our view, he should be treated like anybody else, which is rich coming from this Department of Justice, which is hysterical. Their boss is Joe Biden and Merrick Garland, and they're telling us that nobody's above the law here. Tell that to the cokehead in the White House. In our view, he should be treated like anybody else. So Trump should just be thrown, I guess in the gutter with what, the J6ers? Is that what they want to? Or what? Should he be treated like Joe Biden or Hunter Biden and exonerated completely? Like that? He says, in our view, he should be treated like anybody else. And so we see that plainly as a tension here. But our view, we think is supported by the Constitution, says Bratt or whomever, and the United States Court of Appeals for the 11th Circuit, and not to mention a fundamental tenet of the Republic. Oh, gosh. In short, Mr. Trump is not the president. He is a private citizen who has been indicted by a lawfully impaneled grand jury in this district, and his case should be governed by the Constitution, the United States Code, and the federal rules of criminal procedure, just like anyone else's. Because he still is pretending, they're like role-playing, that he's a part of a legitimate institution, and that it's a legitimate actual indictment, and all of this grand jury is all impaneled appropriately, and that none of this is done extra constitutionally in the first place. But of course it is. Julie shares this about Trump's lawyers, talking about classified papers in boxes at Mar-a-Lago while he was still president. She tells us that Smith is going to have to prove that any record in the indictment was indeed taken to Mar-a-Lago after he left office and contained in boxes shipped to Mar-a-Lago after January 2021. Here's a clip. This says, this isn't a case that's like many other cases in federal courtrooms around this country. The fact that President Trump was indicted and the reason why he was indicted for possession of classified documents, purportedly classified documents in a series of boxes in his residence, many of which were moved, we believe, before President Trump even left office. Some of them were maybe there afterwards. We don't know. That's something we're looking at in discovery. So timing of the movement of the boxes. Julie's laughing. She says Jack Smith has the equivalent of 3 years of security camera footage. Trump's team wants to try to watch all of it. Of course they do. Every lawyer needs to watch all of it. We need multiple opinions, man. And we got to watch it on slow-mo too, just to make sure it's all framed. Our experts have to watch it too. Man, it's going to take probably a decade to watch all of it. I'm just saying, it's going to be complicated, man. Defense attorneys, we're not that bright either, okay? We are not very good with technology. So they're going to send us CDs and hard drives and terabytes, and we're going to be like, oh no, how does it work? The algorithm. It's all proprietary classified crap. We're going to be mashing 2 rods together. Is this how it works? Oh, I don't know. Is it going to plug in here? All delayed until, weird, after 2024 election, November, then suddenly everything's going to start working. Oh, thanks for the discovery. Now we're ready for trial. Trump's president. Let's go. So it's going to be amazing. But the DOJ says, no, you don't need to look at anything. You can just trust us. We're the DOJ. We're legitimate. Judge Cannon says, no. That's not how that's going to work. Here's the transcript. Now, this looks like it's Trump's attorney talking. Says, all right, Your Honor. Now, I'm not suggesting Trump's lawyers. I'm not suggesting to the court that we're going to sit here, okay, for 3 years and watch 3 years' worth of video, which is nice of him. But it's a tremendous amount of data and information, Judge, okay? I'm just talking right now about the CCTV footage, that's all. While the government is correct, they're right, that they have pointed us to the few days that they believe are the most significant to them. They're like, it's the 13th and the 8th and the 14th. And they say it relates to the charges in the indictment. That's what we charged. Here's the dates that are charged in the indictment. Here are the dates on video. This is what you need. And presumably that's in the search warrant. They say they're not the most significant to us. They might be important to them, but not to us. Trump's defense says, the The movement of boxes and where boxes were on given days, the movement and where the boxes were on any given days is extraordinarily significant, not only to the justification for the search warrant, which means we're going to get a motion to preclude that search warrant is going to be challenged. They're going to try to get that search warrant thrown out. It's significant to the justification for the search warrant of the residence of Trump and the president, but also to the defense of the case. And so the CCTV footage alone, over 1,100 days of CCTV footage, Your Honor, makes the schedule that the government proposed pretty disingenuous, Your Honor. There's just no way that we could do it. And they know it, and we know it, and they know we know it, and they know you know it. And so what they're doing is they're trying to just shove this through. It's dishonest. Now, the government prosecutors are complaining back. They say, Your Honor, well, with respect to the closed circuit television and the movement of boxes, I just want to note that the movement of boxes occurred between May 24th and June 2nd. So it's not years worth of video with respect to the movement of the boxes, okay? And with respect to the classified information, I know Trump's lawyer, Mr. Blanche, and the judge jumps in and says, hey, the defense would have to review all of the footage to be properly informed about the scope of the footage. Obviously, they're going to review it all. Judge Cannon says, I mean, it's not the case that we're going to zoom in on whatever period of time the government isolates as critical. And prosecutor Bratt says, of course, but a lot of what they're going to be doing is having, not themselves, is having somebody run through the video and seeing essentially nothing happening, or, seeing somebody walk across a particular area and being filmed. He's like, hey, you can fast forward through it. None of the people who have any relevance to this case, he says, but yes, yeah, that takes time, Judge. It's not like reading documents. It's, it's like viewing something. So the prosecutor, he's like, it's not that hard. You're just going to sit there and fast forward this thing. Whether it's coming or not, they'll be able to go through it quickly. Now, we've got some legitimate venue arguments, according to Miss Julie Kelly. She says the judge, Beryl Howell in D.C., who's an Obama appointee, who also oversaw the Mueller investigation, gave the DOJ, then Smith, everything they wanted, including an order to pierce attorney-client privilege from Evan Corcoran. Then they moved everything to Southern Florida. Involved a little more than reading a D.C. grand jury transcripts to a new, it's very sneaky. Okay, so Julie Kelly is telling us that they did a bunch of stuff in Washington, D.C., and then got the information. So the D.C. judges just allowed them to do whatever they wanted. Jack Smith, his special counsel, they're like, hey, we're the lawyers here to fight against the insurrectionists. And the judges are like, oh gosh, we've been waiting for you. Thanks for saving us. And so they say, whatever you need, you've got it. Here, go attorney-client privilege, shattered. Executive-client privilege, oh, shattered. No problems. Oh, you want subpoenas, you want this. Okay, no problem. Here you go. Everything you need, carte blanche, here you go. So then they get all of the data, all of the information, and they say, oh, well, how about we just take all of this data and shove it down in Florida, because that's where the jurisdiction is. That's where the actual crime needs to be alleged, because the document, it was in Mar-a-Lago. That's where the raid was. That's where the search warrant was and all of it. But they're using information from outside of the jurisdiction to prosecute crimes inside the jurisdiction. In other words, the judge in Florida may not have granted the same requests that were granted and approved in D.C. But Jack Smith is being very sneaky here, and Trump's team is going to be defending this. Says, just by way of one example, as the court knows from the indictment, one of the government's main witness in this case is President Trump's lawyer, and the government was investigating this. The grand jury initially in this case was in D.C., and everything regarding the grand jury and what happened there was in D.C. There's a U.S. Attorney Manual provision that states clearly that a case should not be presented to a grand jury in the district unless venue for the offense lies in that district. There's no scenario under which most of the statutes charged against Trump that would have lied in the District of Columbia. But that being said, that's where this case was presented, and it still continues to be, at least in part, presented there based on our understanding. That's a significant issue, but it requires review of the discovery. It requires review of discovery. The judge says to Trump's lawyer, they say something, Your Honor, we need a careful and complete review being necessary of the, quote, procedures that led to this indictment. She says to the lawyers, can you put any meat on the bones to that? Trump's lawyer says, Your Honor, I think that's what Mr. Blanche was referencing, sort of the search warrant, those procedures. The grand jury procedure that he mentioned is from a case called Washington versus South Florida. Oh, is the districts. Grand jury, Washington jurisdiction versus South Florida have different grand jury procedures. All of the issues surrounding Trump's lawyer testimony, Mr. Corcoran's, and the appropriateness or not of that testimony. In other words, can Evan Corcoran's testimony, which was gathered after permission of a DC judge to breach attorney-client privilege, can the resulting testimony from Trump's lawyer be used in Florida in this prosecution? Because this judge didn't approve the cracking of that attorney-client privilege. A DC judge did. Stanley Woodward, the lawyer for Walt, hints that the DOJ also abused the grand jury process by conducting nearly the entire investigation investigation in a DC courthouse rather than in Florida. So Walt's attorney chimes in. Anything from you? He says, yes, thank you, Your Honor. I just want to pick up where Trump's lawyer, Mr. Keese, left off. I have serious questions about how an investigation that had been pending for months and months and months in the District of Columbia ever even ended up here. What are we doing here in the Southern District? You know, as the court is aware, I was personally involved in a fair amount of litigation in the District of Columbia. This lawyer is representing a ton of J6ers. And so I'm especially curious as we see discovery. I've seen a lot of files in DC January 6 Trump cases. I'm curious to know what was done in DC and then what was done in Miami, and whether there's a motion here for abuse of grand jury process in this case. Those are rare, I understand that, but this is a new case, and we can't bring such a motion before Your Honor without understanding there's any merit there. And the only way for us to understand if we can file that motion is to review the discovery, which is just great. They have some serious issues. Julie says that Jack Smith is going to try hard to prevent Trump from seeing these classified documents. They don't even want Trump to see the evidence anymore. They say, well, he's not president anymore, so he doesn't need to see these classified documents. The argument that a former president who had access to these documents and created the documents, and in my opinion, of Article 2, the opinion clause, they are literally his documents because there's nobody else who has ultimate possession of them. They were his. He has the ultimate authority to them. She says now it smacks of desperation. Trump's lawyer notes at the bottom, it's not a typical case of an unauthorized individual stealing documents. They're Trump's. They say on the classified information, Your Honor, this is, and you asked Mr. Brad about this, Your Honor, there's no case like this. This has never happened before. I mean, the president has original declassification authority. He's one of a few people in this country that possess that as a president. Whether that's part of the review of classified materials, we don't know yet. And Your Honor is right. The proposed protective order right now doesn't allow us to discuss anything with our client as it relates to any of the materials that we see that are classified without getting permission from the government. So we have to go ask the government prosecutors who are through and through Trump haters, or, this is their entire livelihood and career and persona and identity, waking up being Trump prosecutors. They, the defense, have to go to them and say, can we show our client this evidence? They say, no, he's not the president. He doesn't need to see that. Thanks. Trump's team says, and so there are complicated Section 5 motion practice things that are definitely going to take place. And we can't speak intelligently about it yet because we haven't seen the documents. He's hinting that they're going to want to show Trump something and the government's going to want to say no, and that there's going to be a battle over that, and Your Honor is going to have to deal with it. It's a speed bump. He says it's not like a typical case where somebody has classification authority and they illegally possess the documents and then is arrested for that. That's just not what this case is. And so it's going to be something that takes a lot of time, battling back and forth. And so thank you to the transcripts from our friend Julie Kelly. Make sure you're giving her a follow at Julie_Kelly2 on Twitter. A must follow over on Twitter. Great reporting. Now, this is the actual order from Judge Cannon. Here's what she wrote. Not a long order, but with all that backdrop, knowing that this is all going to be contested, we have a 7-page filing coming out of West Palm Beach, Southern District of Florida. The case is USA versus Trump and Walt. Judge Aileen Cannon presiding says, all right, this matter comes before the court upon the government, Jack Smith's motion to continue the trial. They wanted to postpone this all the way back to December. The court has reviewed the motion, Trump's response to the motion. They wanted an indefinite trial date, and the government's reply to Trump's motion, they wanted December. And we held a pre-trial conference and I heard all the arguments about it. And here is what I have decided after my review. It is hereby ordered and adjudged as follows. Jack Smith's motion to continue the trial, he wanted it postponed a little bit. Remember, we were scheduled for August, is granted in part for the reasons stated below. The court finds, Jack, that the interest of justice served by this continuance outweigh the best interest of the public and the defendants in a speedy trial. We do a balancing test. The defendant might want a speedy trial. The public might want a speedy trial, so justice is done quickly. But we might have due process concerns. We might need to properly investigate things, and sometimes things have to slow down a little bit so that we don't just throw people in prison without affording them process. The court has considered the factors in the law when I've made my decision, and having done so, the court finds that the period of delay resulting from this continuance, for example, from the time this motion was filed in June to the trial date, is excludable time under the Speedy Trial Act. And this is why we always have end dates on trials, because if you lose track of how much time has elapsed, you might run afoul of the Constitution, which says the defense has a right to a speedy trial. The judge tells us, this case is currently set for trial in August, with a deadline to file motions in July. All parties agree that a continuance is warranted. Nobody's objecting to postponing this. So we're definitely not going to trial in August. Everybody agrees, even the court. But the parties do disagree as to the length of the continuance and the appropriateness of setting a schedule. They say, let me get this out of the way as a preliminary matter, Judge Cannon. The court rejects Trump's request to withhold a setting of a schedule now. The court deems necessary to manage the proceeding through important stages of discovery and SEPA briefings and motion practice and trial practice, and we don't see a basis to postpone any scheduling order. But we do agree that Jack Smith's proposed schedule is atypically accelerated. Atypical. Why are we going so quickly? And it's inconsistent with ensuring a fair trial. Obviously, they wanted him convicted and sentenced and imprisoned before people walked into the ballots, but they may not get that done now. The judge says, as it stands, the government timeline spans less than 6 months from the first discovery production. And this case involves, at the very least, more than 1.1 million pages of non-classified discovery produced thus far, some unknown quantity of which is described by the government as non-content, they say. It's got at least 9 months of camera footage with disputes about what's pertinent or not, and 1,500 pages of classified discovery that's ready to be produced, with more to follow, she writes, plus additional content from electronic devices and other various sources. And so Cannon says, even by conservative estimates, the amount of discovery in this case is voluminous and likely to increase in the normal course as trial approaches, because this is what the government has created. The defense hasn't even, first of all, seen it yet, and even started asking questions yet. They're going to get one page and they're going to say, whoa, that's interesting. Who's that? Who's that? What did that happen? Where's the calendar invite? Where's the email? What did you have for lunch that day? And who served it to you? Well, they're going to file a request for supplemental discovery. It's all going to go back to the government, and then they're going to, have to produce it. And if they say we're not producing that, then they're going to go to the judge and say, Your Honor, we need it, and they're not giving it to us. And then guess what? That's a whole tangent of a fight, and around we go. And while the government has taken steps to organize and filter the extensive discovery, no one disagrees that Trump and the defendants need adequate time to review and evaluate it on their own accord. Thanks for labeling it for us, okay, with your sticky notes. But here's what we think of your sticky notes. Right in the garbage! To add further complication, a material portion of the discovery in this case is subject to the procedures in SEPA, the judge writes. Procedures that all agree often lengthen the ordinary trajectory of the case from indictment to trial. That is no less the case here, where the matter involves substantial quantity of classified discovery that is yet to even be produced, pending a court resolution of a forthcoming protective order that we're settling. We've got to discuss security clearance briefings, processing of final security clearances for different portions of the classified discovery. We've got logistics reviews, expedited preparations for different accredited facilities. It's going to be a mess. Then there is a matter of extensive pre-trial motion practice, as described by Trump's team in their responses. And the bare minimum of Trump's responses is going to require a considerable amount of time for the court to review, independent upon the merits of the motions. So the judge says, look, I expect to just have to review a boatload of motions. But if the outcome of one of those motions opens up another avenue, that could deviate the whole process. She says that Trump, for their part, they characterize the government's approach to this case as unusually expedited and cursory, which is true. And they, the defense, request additional time to conduct their review of the voluminous discovery. A lot has yet to even be produced yet. And they describe the case as falling squarely within the complex case designation under the law. Trump people, they maintain that this proceeding raises novel, obviously brand new, complex and unique legal issues, and it cites the interplay between the Presidential Records Act, various criminal statutes, constitutional challenges, yes, to the authority of the special counsel to even maintain this action, disputes about the classification of the subject documents, challenges to the grand jury process that led to the indictment, questions of attorney-client privilege, probably executive privilege at some point, requests for defense discovery, pre-trial motions, motions to suppress, motions to sever, and lots more. And as a final category, Trump also identifies various additional factors that the court deems unnecessary to a resolution of the government's motion at this time. Most principally, so unnecessary to the resolution right now, is jury selection stemming from the publicity about 2024. So see this here? This is a back pocket. This card is going right in Judge Cannon's back pocket. She's like, oh, here we go. Gonna hang on to that one here for a couple months. Trump's people say election is going to cause a big problem with getting a fair and impartial jury. Court says we're not going to resolve resolve that right now. Let me hang on to that. Upon review of the parties' competing arguments, government says this, Trump says this, then the government said that again. Says it's clear to the court a continuance is warranted in this case. First, as the record reveals, the discovery in this case is very exceedingly voluminous, going to require a lot of time to review, and Trump needs to do that in order to have a fair trial. And second, this is a classified documents case, which although on its own may not in fact warrant designating this case complex by itself, they say that by itself, the law, however, strongly counsels in that direction, given the following things. We have substantial quantities of classified documents. We've got a SEPA briefing. We've got the need for the defense and the court to review the classified discovery under very appropriate safeguards. We've got a lot of pending logistics. And third, even accepting the government's contested submission that nothing in this case is novel, the fact remains that this court is going to be faced with extensive pretrial motion practice on a diverse number of legal and factual issues, all in connection with your 38-count indictment. These factors, the judge says, are enough to designate this case complex under the law, and the court is unaware of any searchable case where this court, in which any court, has refused a complex designation under comparable circumstances. So the judge says, I've done my research. I've done my homework. I've scoured all of the other cases around this country. This is complex. 38 counts, million pages of documents, 9 months of video files, president, declassified, classified issues, breaching of attorney-client privilege. The list goes on and on. I'm designating it complex. It justifies a long continuance. And for the reasons as stated above, I am scheduling the following pretrial and trial schedule. Now, we are not going to stick to this hard and fast, right? There was already one of these that was written, and the whole thing is now going into the garbage because the judge bumped this whole thing out basically a year. She says the calendar call, which is the final proceeding before a trial, you just go there, you sort of make sure, hey, calendar next week, we're there for trial. Everybody here, defense shows up, government, prosecutor shows up, we're ready. Any final issues? Nope, see you next week. This case set for a 2-week trial, which still seems, light to me, but commencing for 38 counts, although, 31 of the counts are documents, but still. The trial would start May 20th. Now, there's a lot that takes place as we lead up to that. Look at all this stuff. Protective order motion, July. Trump files an opposition. Government responds to Trump. We have a hearing on the motion. We have, remember, every time there's a hearing, there's a ruling, then there's the potential to appeal or special action those, to challenge those in another variety, depending on what the ruling is, depending on what the law says, depending on what these things involve. Then we have hearings. We don't get the initial production of classified discovery until September of this year. Status report. Trump's team is going to respond and say, well, we didn't get this, we didn't get that. Your Honor, we're missing this, we're missing that. We'd like to see this. Government provides a notion, more updates in ex parte filings. This means that Trump files his directly to the judge. The government files theirs directly to the judge. Is the fact that this is May 20th. I thought this is a very interesting date. If Trump comes back and they ask for a continuance or something is askew as we get closer to these trial dates, and I could be wrong. We could have a full trial on this date. I'm just doubting it. But if we do, remember, we are right in the thick of election season now. As it stands, we've got at least 4 states that are going to be going before May. Certainly Iowa is already scheduled for January. New Hampshire's up in the air, but it's early. We've got Nevada and South Carolina, all between January and February. So by the time May comes around, we're going to be getting close to wrapping up and going into the general election season. And so we can't postpone this thing 3 months or 4 months or 5 months. We got to postpone it 6 months, which means it's going to be after the election. May plus 6 is going to give us November 20th, 2024. And if we get there, and let's say Donald Trump wins the White House, well, then he's in control of the Department of Justice moving forward. Not on this date, not until January the following year of 25. But we've got some interesting timing things happening. So we'll see if they stay on track and if they're able to squeeze that in time. I'm not so sure of it. But we've also got reaction on this. MSNBC chimed in on this with Joe and Mika Brzezinski on their show. Here's what they said.
All right, we have a pretty significant update in the classified documents trial against former President Donald Trump. Judge Aileen Cannon just filed a document announcing a date for the trial for the Mar-a-Lago documents case. And that date is that the case will begin May 20th, 2024 in Fort Pierce, Florida. There are also numerous court dates prior to trial listed for various motions. So a lot will be happening before May 20th, 2024. there was a lot of discussion about what the date should be or could be, and both sides wanted something completely different, Joe.
Well, they did. I mean, Judge Cannon, of course, remember, Judge Cannon had been roundly criticized and rebuked by the conservative 11th Circuit for some past decisions. So there had been some skepticism of her ability to handle this case in a fair and impartial way. But I will tell you, I think most attorneys I spoke with thought that the Fed's date that they suggested, the end of December, was probably too soon because of how complex the case was, and thought that Donald Trump's suggestion, his attorney's suggestion that it be held after the election in 2025, also unrealistic. I've got to say, again, I'm an attorney, but I have no grasp of just how complex a case like this could be. When you look at the mountains of evidence that the federal government has against Donald Trump, you look at the files, my God, the files, you look at the fact that we're talking about classified documents. It's an extraordinarily complicated case. I was always skeptical about the December timeline. I must say May 20th, 2024, that seems very reasonable. It seems like a reasonable date. It seems like it's far enough in the future to be fair to the defendant.
The primary.
President Trump, politically it'd be after the primary. But if you're a judge, you're not looking at that. And I think this date makes an awful lot of sense. So we will see as we move forward. But obviously, there's going to be a lot of coverage between now and then. A lot of dates, obviously, court dates, too.
That's the Joe and Mika Brzezinski show. And, you know, I think they're right about it. It is kind of reasonable. It feels reasonable. The analogy is you can't make it on the green in one shot. You've got a long par 5. So you got to drive it into the middle of the fairway to set it in May and then hit it again in May onto the green. And Trump's going to want to do that in May. He'll take another shot at this, pop it off. It'll land on the other side of the election. And so speaking of Trump and strategy and his team, we have a new Trump lawyer enters the game. This guy's name is John Lauro. He showed up on Fox and he had a conversation about Trump appearing for the January 6th grand jury. Of course, we know Jack Smith is looking at bringing an indictment very soon. Trump's already gotten the target letter, so it could drop any minute. And he is saying Trump doesn't need to show up and appear.
But there's no need to appear in front of any grand jury right now. President Trump did absolutely nothing wrong. He's done nothing criminal, and he's made his case that he was entitled to take these positions as president of the United States. When he saw all these election discrepancies and irregularities going on, he did what any president was required to do because he took an oath to do exactly that.
All right, we'll dig more into that in just a minute. But first, you're going to be solely focused on the Jack Smith investigation into the aftermath of the 2020 election. You're also part of the team that was trying to dig into whether others in the former president's orbit received target letters like he did. What have you found?
Well, the bottom line is that the special prosecutor, which is really the Biden Justice Department, is after President Trump, and that's the focus. And they're accusing the president of two things, essentially. Number one, that there was some kind of effort to obstruct the January 6th count. The only thing that President Trump asked is a pause in the counting so those 7 contested states could either re-audit or recertify. I've never heard of anyone get indicted for asking for an audit. What President Trump was looking for was the truth, was to find out exactly what happened in those 7 contested states. That's just not criminal. The other statute that they're looking at is whether or not President Trump intimidated anyone or ballot stuffed. And that's an example of really the criminal justice system being used against the victim. Because here, what the president was saying in real time after November is all these election discrepancies, all these unlawful acts at a state level. And what he asked ultimately is to find out the truth and get to the truth. And that's just not criminal.
Right. Everybody in any election, in any campaign that's ever happened, has always asked a question, what about the votes? They sit around all the time talking about the votes. So if Trump is calling different people who are part of the Republican Party, different elected officials and all of these things to have conversations with them as the commander in chief, as long as he's not crossing the line where he's putting pressure on them and coercing them, which we'll see if there's testimony about that in the January 6th case, he is allowed to articulate and advocate for his position. We live in an adversarial system. When there is a potential for a an illegitimate election, people are allowed in this country to ask questions about it. The Democrats have a history of doing it. We've got minutes and minutes of them doing it. They objected just like Republicans objected, but they don't prosecute themselves. They only prosecute the Republicans when they do it. And so Donald Trump celebrates the May 2024 trial date. I think he should, because I think this was just a chip shot. They'll come back in May. I expect it to be continued again to postpone this until after the election. Now, the January 6th case in D.C., that's a different judge. That's a different jurisdiction. It's going to be a whole different story. We'll be covering them both. Thank you, my friends, for subscribing wherever it is you're watching this as we continue to cover.